Michael Popak, Legal AF. Let me explain the new gag order just imposed by Judge Engoron against Donald Trump's civil fraud defense lawyers, particularly Christopher Keiss, but also including Alina Habba and the others, to stop them from continuing to comment on, become obsessed by, criticize, and attack his principal law clerk. I'm going to talk about what the principal law clerk's role is in the New York State Supreme Court system. I'm a practicing lawyer in the New York State Supreme Court system for 32 years. I practiced before this particular court in this courtroom, and I think I'm uniquely qualified to talk about it and talk about the appellate court just above it, where I'm also a member of the First Department Appellate Division, and why this is just an effort ultimately by Chris Keiss for Donald Trump to seek the recusal or the removal once again of Judge Engoron. They think they're laying a trap for him, but all I believe they're doing is leading to Chris Keiss having his ticket pulled to continue to practice in New York as a Florida lawyer, which he does by special permission by the judge if he doesn't knock it off. Let's talk about what the conflict is, what the ruling is, and what do I think the next step for Donald Trump is that will backfire. One, what's going on with the gag order? The principal law clerk is assigned, or is one assigned, they are a lawyer, assigned to every judge in the New York State Supreme Court. The New York State Supreme Court, despite its name in New York, is the trial level court. Every judge has a clerk, unlike in some courthouses where the clerk is a law student, or the clerk is usually a law student, federal or state. It is different in Manhattan. Chris Keiss, if he practiced here and wasn't a Florida lawyer by training, would know that. Alina Habba, a New Jersey lawyer, doesn't really know it either. There's really no New York lawyer on the defense team that is there helping them. There's only two groups of people in the room that understand New York law, the judge and the New York Attorney General. Everybody else is a carpetbagger who's sort of winging it. I feel like I'm watching My Cousin Vinny, where Chris Keiss is in the Vinny role being lectured by, Edward Herman, Edward Gwynn every day as the judge. So look, here's the story. Principal law clerk, you always a lawyer. That position often becomes judges. Many principal law clerks make their way onto the bench, either by running for office or being appointed by the governor. It's a stepping stone to that kind of position. They help the judge throughout the day. We treat them in New York as sort of mini judges. We treat them like magistrates, if you will, in the federal system. I've had a principal law clerk lecture an opponent of mine to say, don't talk over me in a conference call, meaning the principal law clerk. You treat me like you treat the judge in a courtroom. And that made sense to me because that's the role of the principal law clerk. And there's laws and there's administrative codes that govern that relationship. And it's a sacrosanct relationship that's protected, just like the attorney-client relationship is protected. The judge-clerk relationship in New York State is sacrosanct and paramount and highly confidential. They don't like the fact that she's doing her job. And part of her job, especially in one with lots of testimony, is to point out to the judge whatever she feels she needs to point out about a witness's testimony, about a piece of evidence, about a prior ruling, about some sort of level of consistency, because the judge is the trier of fact. So she's assisting the trier of fact to try the facts. And one of the ways you do that, rather than interrupt what's going on and the cadence and flow of the examination or witnesses, is that you do what I'm doing. You write a note and you pass it to your judge. If the judge is technologically sufficient, which Judge Engoron may or may not be, you do it by computer. In fact, if she did it by computer, Chris Keiss wouldn't even have known what she was doing. You would just, or direct message, right? Boop, 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 boop. That's my direct messaging signal. Pop, 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 pop. Judge says this. Law clerk says that. Judge says, I don't think that's consistent with prior testimony. Law clerk says, I think you're right. Let me look it up. No, I just looked it up. You're right. And they're doing back and forth. Instead, this apparent judge likes to have handwritten. She's old school. Here's notes, right? Like you're in class. Chris Keiss doesn't like that. Oh my God, the principal law clerk. She's a human being. She has maybe political leanings, and she's passing notes to the judge. I mean, it is outstanding, the naivete and the lack of sophistication by Donald Trump's lawyers masquerading as some sort of legal expertise. I would be embarrassed. Let me put it this way. I would be embarrassed to be making the arguments as a New York barred lawyer and a part of the First Department that Manhattan is a part of, and a sworn officer of law and an officer of the court, to be making the arguments that Chris Kice is making. I would never attack a principal law clerk unless there was real unethical conduct that I had my hands on in terms of evidence that I could point out, which in 32 years, I've never seen a clerk be biased against a case sufficiently or anyway to warrant having them removed from the case. So why are they continuing to bash every day, every way the principal law clerk? And why has the judge just ruled that that shall not go on any longer? And in his new gag order, which is now out, we've done a hot take on it, has ruled that it will no longer happen. And is basically implied that Chris Kice is going to have his license, permission to practice in New York for the limited purpose of this case yanked if he doesn't knock it off. Because when you're pro hoc, meaning you're admitted specially from another state, it's at the pleasure of the judge. And if the judge feels like you have violated and you are not comporting yourself the way a New York bar member would, you're out of here. You're thrown out. So he reminds Chris Kice in the beginning of his order, he says, over the past week, this is on page 1 of his order at the bottom, defendant's principal attorneys, namely Chris Kice, admitted pro hoc vice. That is a subtle threat to Kice to remind him that his ticket to operate in that courtroom could be pulled by the judge. Clifford Robert and Alina Habba have made on the record repeated inappropriate remarks about my principal law clerk, falsely accusing her of bias against them and of improperly influencing the ongoing bench trial. Defendant's attorneys have made long speeches alleging that it is improper for a judge to consult with a law clerk during ongoing proceedings. This is the embarrassing part that I would never raise. And the passing of notes from a judge to a law clerk or vice versa is an appearance of impropriety. That's they're trying to get the judge disqualified or accused. He then cites administrative rules and court rules about the ability of a judge, the necessity of a judge to consult with his law clerk, and about the ethics opinions in New York, which are legion, about the relationship between a law clerk and a judge being one of trust and confidence, right? And he goes on to say in the order, as I've stated on the record, seemingly to no avail, my law clerks are public servants who are performing their jobs in the manner in which I request. Right? They're entitled to continue referencing my staff, yet they're continuing to reference my staff in the record. The judge ends it with, First Amendment arguments are not availing. This gag order stopping you from attacking or referencing the relationship between me and the principal law clerk, the logistics between me and the law clerk, the note passing or information exchange between me and the law clerk stops now. That's the gag order. And that's sufficient. Because if I were the judge, I would have already pulled Chris Kice's ticket. I would have lectured him and hectored him in this opinion. And I would have said, you obviously do not know how to practice law in New York, and therefore you will not practice law in New York. And we can rely on the other lawyers here because you have to comport with and it's assumed that when you take that oath to practice here as a pro hoc admitted lawyer, that you will comport and know the laws of this jurisdiction. And you obviously do not. I've warned you more than once. It's also, like I said, this embarrassing fundamental misunderstanding of how the New York court system works and its many constituent parts. I mean, it's almost like, I would say it's almost like Chris Kice doesn't know what a law clerk does in the state of New York, but it's obvious that he doesn't. I mean, I'm almost waiting, back to the Cousin Vinny analogy, I'm almost waiting for Chris Kice to say to the judge, in response to an order like this, oh, you were serious about that? Yeah, he's serious about that. You can't wear a leather suit in court, and you can't attack the normal interactions between the trier of fact, the judge, and a law clerk. I've given you many examples, even though I don't have to defend the law clerk or the judge here, where that should happen. The judge is the repository of all the knowledge in a case, that and the documents in the record. The judge, as a human being, is the trier of fact and has to ultimately write a decision and order in this case after many, many weeks, months of testimony. Hundreds of hours of testimony, hundreds of thousands, if not millions of pages of documents. How does Chris Kise think the judge does that? By himself or with the assistance of staff? How does he keep track of the continuity of testimony? That Eric contradicted Don Jr., that Don Jr. contradicted Ivanka, that's not what the document said from 6 days ago. You think that's all in the giant computer of the judge's mind? Or is the principal law clerk also looking at the transcript that's being prepared of the testimony each day and pointing out to the judge inconsistencies? Why is it important? Because the judge, not the jury, there's no jury, is the trier of fact. He has to reconcile the competing and conflicting testimony of various witnesses. He has to evaluate the credibility of witnesses. That's his job. Her job, or whoever sits in that chair, her job is to assist in that process and in that enterprise. And that's all we're watching. They want to make it sound like it's some sort of, a coven den of witchcraft that's going on in the courtroom between the principal law clerk and the judge, when all they're pointing out is ordinary, traditional communications that are necessary for the proper administration of justice. Chris, seriously, have a seat. Stop attacking our New York court staff, our New York justices. If you don't like the case and the way cases are tried in New York, you can head on back to Florida. Okay, I'm a Florida bar member too, by the way. And I know Florida practice. And Florida practice isn't New York practice. So I can also speak to that. When I appear in front of a New York judge, that's one thing. I understand the role of the law clerk in the almost magistrate-like decision-making process, like a junior judge. Down in Florida, it's a whole different thing. There's no clerk. There is a judicial assistant. It's called a JA. The JA is the gatekeeper, generally not a lawyer, generally an administrative clerk that's been with the judge for a long, long time. Sets hearings, sets control dates, helps the judge manage his calendar, manages his courtroom, right? You reach out to the JA when you try to get in on an emergency hearing down in Florida on something. But the judge writes their own decisions. Sometimes they have for the summer a clerk, but most judges in Florida at the trial level don't have clerks at all. They have judicial assistants. Chris Kise operated as an appellate lawyer. He generally went to various levels of appellate court throughout the state of Florida and up to the Supreme Court of Florida. A whole different ball of wax. This ain't for the faint of heart. This is Major League Baseball in New York with rules apparently of which you are not familiar, Mr. Kise and Ms. Haba. And it should stop now. But they don't want it to stop because they want to keep pressuring the judge to get him recused. The judge even said, you want to recuse me? You got more than enough things that you can bring up in your motion. Bring it now. Judge was like, almost like, you want a piece of me? That's very New York. Well, he used to be a taxi driver, the judge, and he's also a musician, so he's got a life outside the courtroom, but he was almost like, Robert De Niro in Taxi Driver. You talking to me? You want to bring a motion? Bring the motion now. You have enough things that you can put down on a piece of paper. Bring it now, because he's confident that ultimately under the scale that's weighed against recusal, that they're going to fail. They're not going to get him recused because they don't like the way he interacts with his principal law clerk. But this is the next thing I'm going to report on my next hot take on Legal AF. It's going to be this. That Donald Trump's lawyers are moving to recuse Judge Engoron because of his interactions with his law clerk and because they got gagged the second time. And the same thing's going to happen. Here's my prediction. At the First Department Appellate Division, New York, where I practice and where I was sworn in 1992, they're going to lose. And it's going to be over. And this case is going to be over, and they're not going to stay the case. I know every witness likes to get up that's named Trump and try to stay the case. Stay the case. Stop the case. I don't want to testify. I can't get babysitters for my children, Ivanka Trump. Stay the case. There's issues that have to be resolved. They're not staying the case. The case is going to be over by the time the appellate court rules, and by the time they rule, they'll say that most of it is moot. because it's already been adjudicated by the judge. This is a freight train without a brake that's heading right for the heart of Donald Trump. And as I said, in a perverse game of Monopoly, it's going to take away his buildings, his houses, his real estate, his money. And that's what we're watching in New York with Judge Engoron. We'll continue to report it here on the MeidasTouch Network on Legal AF. If you like this hot take, give me a thumbs up. Helps with the ratings, helps keep this thing alive. And until my next hot take and my next Legal AF, Wednesdays and Saturdays, 8 p.m. Eastern Time on this YouTube channel, MeidasTouch. This is Michael Popak reporting.
Hey, Midas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.